Court will start by calling 2017-195, State of Arkansas versus Tyra Pruitt. Miss Pruitt, can you hear the court all right?
Yes, sir.
Okay. You're appearing before the court for arraignment on charges of possession of a controlled substance, methamphetamine and cocaine, Class D felony, and possession of drug paraphernalia, Class D felony, and furnishing prohibited articles, a Class C felony. Have you made any arrangements at this point to be represented by an attorney?
No, sir.
Can you speak up just a little, please?
I said no, sir.
All right. The court is advising you have serious felony charges, as I've just stated. It's in your best interest to get yourself represented by an attorney. Your choices are to employ the attorney of your choice. As long as you're hiring private counsel, the court doesn't get involved in that. That's a matter of private contract between you and whoever you choose to hire. If you cannot afford to hire an attorney, you're still entitled to an attorney, and at that point it means that you're entitled to appointed counsel through the Public Defender's Office. In order to get appointed counsel, you'll need to fill out an application for the Public Defender's Office. Those applications are available there through the jail, and you can get that filled out and turned in to get appointed counsel. Those are your choices on securing counsel. Do you have any questions about that?
No, sir.
All right. I read off to you the charges that have been filed by information against you at this time. How do you now plead?
Not guilty.
I'm noting your plea of not guilty. Your case is assigned to the Division III docket. That's Judge Putman's docket. Judge Putman will be holding court on May 11th, and I'm going to put you down to reappear on May 11th in front of Judge Putman.
Your Honor, I think that there are applications over there. You may have already gone over this with her, but I just saw a jailer behind her, but if she wants our services, then certainly there are forms over there for her to fill out.
I've explained that to her.
Right.
She says she understands that. So, all right. If you have no other questions, then court will excuse you at this time. 2017-192, State of Arkansas versus Bryan Glade. Mr. Glade, have you made any arrangements to be represented by an attorney at this point?
Yes, Your Honor. I filled out the public defender form a few days ago.
Okay. Has the Public Defender's Office received that application?
Judge, we have not at this time, but based on the fact that he's filled it out and he's incarcerated, at this point in time, we would go ahead and enter a plea for him and get that information to the court.
Mr. Glade, you're for arraignment today on charges of possession of controlled substance, methamphetamine, Class D felony, possession of drug paraphernalia for use with methamphetamine, it's Class D felony also, trafficking in methamphetamine, a Class Y felony, possession of marijuana with the purpose to deliver, a Class C felony, possession of drug paraphernalia with the purpose to deliver methamphetamine, a Class B felony, possession of drug paraphernalia with the purpose to deliver marijuana, a Class D felony. On those charges, how does the defendant now plead?
He pleads not guilty, Your Honor.
That plea of not guilty is noted on the record.
Judge, if we could address his bond, I'm not sure if the court has a notation of what it is at this moment.
The indication is it's $100,000.
He's got a, okay. Judge, it's my understanding that he's on probation or maybe parole and has a revocation pending, so I'll look more into this matter, and if bond's an issue, we'll bring it up at a later time.
Very well.
Thank you, Your Honor.
You may be, sir, you're on the Division 4 docket. With that in mind, the court, having noted your plea of not guilty, the court's going to set you down by scheduling order. Scheduling you, let me check on this. Apparently, April 25th is the arrest date on this matter. And the court is going to set the matter down by scheduling order for a reappearance date of June 22nd. That'll be to check on the status of the case. April 17th will be the pre-trial date. August 17th will be the pre-trial date, and October 23rd, that week of October 23rd, it'll be set for trial. Those dates will be in a written scheduling order filed in the case. At this point, you may be excused, sir. (2016-38) State of Arkansas versus Vanessa Henschel. Mr.
Honor.
Cooper, this matter, we had we'd entered an order for her to receive an evaluation. I think that's correct, isn't it?
That's correct, Your
That's
Honor.
correct, Your Honor.
Evaluation has come back,
Which
Your Honor.
type of evaluation was it?
Order for fitness to proceed.
Well, I thought. Okay. Court has received and reviewed an evaluation. Essentially, the evaluation makes a finding that she refused to follow the evaluation protocol and was uncooperative and oppositional during the evaluation. The court's going to direct that this evaluation be placed in a sealed envelope and made part of the file of this matter. Where does that leave us, Mr. Cooper?
And I think it leaves us at this point with needing to get a trial date. I attempted to visit with Ms. Henschel at the jail on Monday. She was not talking to me, and I understand from talking to jail personnel that she is not talking to anyone at the jail also. So at this point, Your Honor, since she was unresponsive to me, I don't know of any other thing to do than get her a trial date, and hopefully she'll start communicating with me so we can get prepared.
Ms. Henschel, are you willing to discuss the situation with your attorney? Are you going to answer my question? Well, let me ask first, Mr. Cooper, have you had any opportunity to to have any discussion with the defendant about her case?
No, Your Honor, I have not. I attempted to do that on Monday, and
Right.
as I said, I even...
But I'm meaning back before. Had you had any contact with her?
Your Honor, I don't recall if I did. If I did, Your Honor, it's been so distant in time, it would not be of any benefit to Ms. Henschel or myself.
All right. Let's set this matter down on a trial order with trial in July. When are our dates in July? The week of August 7th. We'll set it for August 7th.
Thank you, Your Honor.
Two thousand 16-58, 2016-346, State of Arkansas versus Nicholas Tomi. Good morning.
He is in custody over there. I do have a pending motion. This is set for review. We entered our appearance some time ago, and then on the heels of entering that appearance, we filed a motion for release to inpatient drug treatment. I know the court is familiar with Mr. Tomei, and his mother, Ms. Stoner, is in the courtroom. We filed a motion asking that he be released to Care Center Ministries. I have spoken personally with Ty Cotter from there. He does have a bed available to him. He has indicated that he will not, Mr. T will not put up with anything with regard to anything that Mr. Tomei does with outside of the rules. He will contact the Baxter County Sheriff's Office immediately. Prior to me having that conversation with Mr. Cotter, I sat down with Nicholas. I explained to him what would be required of him. He's all for it. He's been clean for 5 months. He just wants the opportunity to get the tools that Ty can give him so that he can maintain some sobriety and then hopefully resolve all these cases in the near future. State objects.
Mr. Etheridge.
Your Honor, the prosecutor's office has been very supportive of Care Center Ministries. Mr. Tomei is not the person we want over there. Mr. Tomei has violated every opportunity we have given him to try to do the right thing while he's been on a bond. Why he's in jail right now is continuing to fail drug test, despite being given numerous opportunities. We don't believe he's compliant. We don't believe he will be compliant. This is not the type of individual who needs to be at Ty Cotter's facility. In our minds, based on what we're trying to accomplish by using that facility, Mr. Tomei has been clean. That is correct for the last 5 months because he's been in the Baxter County Jail for the last 5 months. It is also the belief of my office and law enforcement, given the opportunity, Mr. Tomei will continue his illegal endeavors that got him placed incarcerated at this time, Your Honor.
If I could just momentarily reply.
You bet.
Mr. Tomei is an addict. I know through my experience being an addict what this drug does, this methamphetamine that we're all here for. It rewires your brain. And it rewires it so much that when it's a part of your brain and a part of your frontal lobe, you strive for it and you go after it just like you would food, just like you would water, just like you would shelter. That's the addiction. That's what pulls you in. That's the reason why he does what he does. Him being in the Baxter County Jail, sure, it gives him continued sobriety, but what it doesn't do is it doesn't give him the skills necessary in order to cope with the issue of addiction. That's the only reason why we want Mr. Tomei to be over there. Yeah, I understand he's had some chances. I get that. I can't tell you how many clients I've had or how many people have appeared in front of this court who've had numerous chances because it's an addiction. You can't help it. Your body almost feels like it has to have it. And I understand, he makes choices and doesn't make choices, but this program gives him the opportunities to make better choices about what it is that he's going to do with his future. He has to have it. He needs it. And I'm not saying that in the end that he won't end up doing some prison time. He may very well, and he understands that. But it's about giving him the tools necessary before he gets into that facility or gets into that environment so that he can properly be a good member of society when he does get released from prison.
First of all, do we have a trial date set?
I don't believe so. It's just set for a report right now. We do not.
I think we had trial dates set, and then when you entered the case,
Correct.
I think you got moved off the trial date.
Yes, sir.
That's the first thing I want to do is get a trial date set.
Very good.
And Your Honor, I would add to all the things been said, we're not talking about somebody who uses methamphetamine. His position in the state, he is a deliverer of methamphetamine. Also, this individual has been through this court's drug court program. He's had the opportunity.
I think before this all before I got involved and shaken out, it was set for June 26th. I would ask for a July date or an August date if that's agreeable to the court. With the pretrial to possibly resolve the case.
State is ready, Your Honor.
And I'll be ready whenever the court wants me to be ready.
I'm remembering that the state had a problem with the July date.
Your Honor, if I have bodies, I can bring bodies if we need to, Your Honor. If this court needs to have this case resolved, I can make sure I have somebody can try this case, Your Honor.
Let's set it for July 17th. The week of July 17th, and I want we'll put it down for that June 22nd pretrial date.
June 22nd, Judge?
That's the pretrial date.
Thank you, Your Honor.
And we've already had a suppression hearing in the matter.
Correct.
Now, I've heard argument of counsel going both ways on his release. My preference would be to simply take this matter to court and give him as prompt a trial as possible. That's what we were trying to do when Mr. Benka, when you entered the case.
Yes, sir.
Can you give me any reason why I should expect him to acquire tools to deal with his addiction when he spent 2 years in a drug court program? He's been through treatment programs before. Why is he more likely to benefit from treatment at this point than apparently he did in those previous ones?
I think 5 months of sobriety, I think will do it. He's been in an environment that I think has shaken his resolve. I think that he wants to do the right thing. I have seen a gradual turn with regard to his personality from the first time that I met him up until now. I know that his mother has been adamant and been constant supporter of his, and I just think he's got a good support system. You know, I don't have all the answers. I can't tell you whether he's going to not do well or do well in there. All I can tell you is that that facility is better equipped to give him the responses and to give him the answers that he needs in order to be sober. I don't think the jail does it. Does it keep him sober? Sure it does. But if he does go to jail, if we do work out an agreement where he goes to prison, he's going to be eligible for the RDAP program, which would be another drug treatment facility in there. So the continued care where he's encouraged to get beyond this addiction, I think is the best thing we could do for him instead of putting him in a jail cell. And we got a facility that's willing to take him and understands the dynamics that the state has outlined with regard to his priors, with regard to his prior addictions. I mean, Ty knows all of that. It's just, I mean, when do you give up? I don't understand that you ever give up with people who are addicted.
No, I understand that. This court has a lot of experience with it as well.
Yes, sir, I know you do.
And
The week of July 17th. Not July 7th, the week of July 17th.
yeah, I thought that's what I said.
I'm sorry.
July 17th.
Yes,
It's August 7th and July 7th.
correct.
Right. Okay. All right. So we're setting this matter down for the week of July 17th. Pretrial is on June 22nd. Well, ultimately, the court, at this point, having had considerable experience with Mr. Tomi, does not is concerned primarily with the possibility that he will not take advantage of the treatment program based on the court's prior experience of him not taking advantage of earlier treatment programs. The court's not going to authorize his release to that program. The court's concern isn't that he would flee. The court's concern is that he will can continue as an addict to use and get back into to finance his use will be done by, as he's done, as allegedly he's done, by selling, getting back into selling. For that reason, the court's going to deny the motion.
I appreciate your consideration, though, Judge.
Well, you know.
I know it's a tough call.
Well, it's, you know, it's one of these things. I have a drug court program because I don't want to give up on people.
Yes, sir.
But we've done, I think, in this jurisdiction, about all we can do on Mr. Tomi's behalf, and the allegation, at least, is that he's gone right back into it and is selling to other people. So,
Thank you for the consideration, Judge.
so we're down on that trial schedule as said.
Yes, Your Honor.
Very good.
Thank you.
Thank you. (2016-152), 2016-197, State of Arkansas versus David Gangler. My understanding is there's a pending evaluation of this matter.
Your Honor, the evaluation was actually received back by us, I believe, late last week. I don't know if the court's had a chance to review it or not.
Okay. Do we need to set this matter down for hearing on the issues of the evaluation, or is the evaluation being accepted by the?
Your Honor, at this time, I'd like to set it for a hearing. I may withdraw that request, but I would like to set it for a hearing, and I'm fine with setting it on the 18th.
Okay. I'll set it. I'm going to set this. For the hearing will be set for May 18th. And then, based on my understanding of the findings as indicated, and this evaluation needs to be filed in each case under seal. Now, what I'm going to do is, because we're setting the hearing so promptly, I want to I'd like to once again I'd like to set this matter down for trial the week of August 7th.
That's fine, Judge.
And we'll deal with any issues on the evaluation on May 18th, and then there wouldn't be time, in this court's opinion, for defense to get prepared for trial by whatever the June date is. So I'm putting it down for trial August. We'll put it on everybody, get it on everybody's trial schedule for the week of August 7th, with a pretrial on July 6th. The pretrial deadline would be July 13th.